Supreme Court dismissed the appeal in the case of LOKU versus the state of Uttar Pradesh and said that we find no reason to interfere with judgment of High Court which is hereby affirmed. Considering that incident was of year 1984 and appealed judgment of High Court was of 2010, Supreme Court said we deem it fit to direct the competent authority to consider and decide the case of accused for purpose of remission strictly in accordance with applicable state policy within a period of 4 weeks from this judgment. The factual matrix of the case was that on 19 March 1984 at 9:30 a.m., prosecutrix went to take tuition classes for girls at the house of accused. It was stated that out of the two girls, one went to bathroom and other was sent by accused for bringing water. It was further stated that when she was engaged in the work on the first floor of house, accused entered the room and latched the door from inside and forced her on the bed. Prosecutrix tried to raise an alarm, but her mouth was gagged with a piece of cloth. The accused then removed her salwar to make her naked. It was further stated that she tried to resist and run away from accused, but he held her by force and committed rape on her. In the meantime, girls reached there and knocked the door, which was not opened. Accused threatened prosecutrix if she raises hue and cry about incident, he will kill her. Grandmother of girls eventually came to the rescue and brought the prosecutrix on the ground floor. Due to outcry of prosecutrix, local people gathered at the place of the incident. She was taken to her own house by Uncle Nand Kishore and she narrated the entire incident to her mother and uncle. When family members attempted to lodge the report, inhabitants of the Mahalla and family members of accused threatened them with dire consequences if they tried to intimate the incident to police. Subsequently, written report was submitted at police station by prosecutrix and case was registered under section 376, 323, 504 and 506 of IPC. After investigation, charge sheet was submitted against accused in the court. Case was committed to Court of Sessions by learned magistrate and charges were framed under 376, 323, 506 of IPC. Supreme Court said that prosecutrix was a major girl studying in first part of BA at the time of the incident. Though she subjected to detailed cross-examination, she stood firm and unshaken, disclosing the incident in detail regarding presence and participation of accused in ravishing her. Merely because in the medical evidence there are no major injury marks, this cannot be reason to discard otherwise reliable evidence of prosecutrix. It is not necessary that in each and every case where rape is alleged, there has to be an injury to the private part of the victim, and it depends on the facts and circumstances of particular case. Supreme Court said we reiterate in the absence of injuries on private part of victim is not always fatal to the case of the prosecution. According to the version of prosecutrix, accused overpowered her and pushed her to bed in spite of resistance and gagged her mouth using a piece of cloth. Thus, considering this very aspect, it is possible that there was no major injury marks. In present case, prosecutrix was continuously threatened by appellant that she will face his wrath if she creates a commotion. The prosecutrix was hence forced to submit to lust of appellant and was left with no other alternative than to submit to evil wish of appellant. It is settled principle of criminal jurisprudence that evidence of prosecutrix in case of rape is of same value as that of injured witness and conviction can be made on basis of sole testimony of the prosecutrix. In the case of State of Punjab versus Gurmeet Singh, Supreme Court observed if evidence of prosecutrix inspires confidence, it must be relied upon without seeking corroboration of her statement in material particulars. A profitable reference can also be made to case of Bharwada Bhoginbhai Hirjibhai versus State of Gujarat, where Supreme Court observed in the Indian setting refusal to act on testimony of victim of sexual assault in the absence of corroboration as a rule is adding insult to injury. Why should the evidence of the girl or woman who complains of rape or sexual molestation be viewed with the aid of spectacles fitted with lenses tinged with doubt, disbelief, or suspicion? Question of conviction of accused for rape of prosecutrix is independent and distinct. It has absolutely no connection with character of the mother of the prosecutrix and seems to be a dire attempt at using it as a license to discredit the testimony of the prosecutor.